Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Shihab bin Noman. My metric number is 1230172 and I am from TLD1. For the subject LAB 2013, the case that I choose for my individual presentation is Majlis Agama Islam Negeri Pulau Pinang against Abdul Latif Hassan as Administrator of Estates of Haji Muhammad Haji Abdul Razak, deceased and honor 2016 to CLJ 150. There are 10 contents for my individual presentation, which is: first is case overview, second is objectives, third is fake of the case, fourth is court held, fifth is issue, sixth is discussion, seven is justification, eight is recommendation, and nine conclusion. For the case Majlis Agama Islam Negeri Pulau Pinang against Abdul Latif Hassan, the appellant name is Abdul Latif Hassan. And this case is hearing dates on 30 October 2017, and the court for this discussion is High Court Penang, and presiding judge is Abdul Wahab JC, and this case is referred to the Muhammad Habibullah bin Mahmud against Faridah binti Datuk Talib 1992 to ML 7931993 CLJ 264 SC DISTD. There are four objectives that I found in this case. First is to know the origin of the land that is said to be Waqaf. Second is to know the extent to which the fatwa was used in solving this case. Third is to find out what arguments were used by both sides during the trial of this case. And fourth is to know steps taken by the judge to give a decision to this case. The fact of the case is, according to the deed and indenture executed in 1882 and 1905, someone named Haji Idris gave his land to Haji Abdul Rashid to be held our trust for the purpose of using the land for mosque and land Islamic cemetery. Second, we're receiving information about the existence of deed and indenture and conduct own investigation in relation to it matter. The Penang State Fatwa Committee has issued a fatwa by deciding the land as Waqaf. The committee has obtained the approval of the Yang di-Pertuan Agong related to the fatwa according to the section 48 of the State Islamic Religious Enactment Penang 2004 and has published the same in the Gazette. Section 89 of the State Enactment declares the plaintiff as sole trustee for all Waqaf properties in the island state Penang, notwithstanding any provision to the contrary contained in any instrument or declaration making governing or affect it. Section 90 of the enactment provides that all Waqaf property in Penang are vested. The plaintiff asserted that the sale was against Islamic law related to Waqaf and filed this lawsuit to set aside all dealing with the said land by defendant 1 and defendant 2 or any other party about the reason the land is vested with the plaintiff under the enactment. The plaintiff requested an other to be registered as the owner of the land and that defendant 2's name in the title did be deleted. Before trial of this action, defendant 1 did not successfully apply before the judge another high court to quash the suit of the plaintiff below Acta 18-19 rules of court 2020 on the grounds that the court is absent jurisdiction to entertain the suit because it contains matters related to Islamic law, namely fatwa and Waqaf, which is solely within the jurisdiction of the Sharia court. This asserted the defendant 1 asserted that the suit had expired under section 6 and 9 of the limitation of time at 1953 and that the title is indisputable, which obtained by the defendants on the said land under section 340 the National Land Code cannot be questioned. Defendant 1 has filed appeal against the rejection of the annulment application but later has withdrawn it. Court held. First, allowing plaintiff's claim without damage. Second is dismissing defendant 1's counterclaim. Third is declaring that the land is vested to the plaintiff and that all dealings with said land by defendant 1 and defendant 2 is invalid and should be set aside. Fourth is order that the plaintiff registered as the sole owner of the land in place of defendant 2. issue of the case. The issue is whether High Court had to give effect to both the fatwa ruling and Waqf status of the land, as their validity was never challenged in the Sharia court. The discussion: selling Waqf land is illegal in Islam, and civil courts do not have the authority to discuss cases that fall under the jurisdiction of Sharia courts. Justification for this case is Section 4 in bracket 2E of the National Land Code KTN clearly provides that KTN is not extended to Waqf land. The defendants therefore cannot rely on 340 KTN and or the National Land Code at Penal Property Rights and Malacca 1963 regarding Waqf land. Through the operation of Section 89 and 90, the enactment, the land is automatically vested in the plaintiff. Therefore, any other giving title to the said land to any party other than the plaintiff is illegal, null and void, and should be set aside, regardless of the application of Section 4 bracket 2E. KTN in this case, the question is the same, whether or not the defendant 2 is bona fide buyer, for the value is no important because defendant 1 does not have the legal capacity to sell the land said to defendant 2. Any right or interest acquired by defendant 2 related to the land has been obtained through an instrument invalid and rebuttable under Section 340 2B KTN, provided to Section 343 KTN is not available to the defendant. The recommendation that I got from this case is we can learn how important Waqf land registration is. Therefore, Waqf are advised to register the land they want to Waqf with the Islamic Religious Council, and Muslim must know that the case to be brought in court is under the jurisdiction of the court. And for the conclusion, Sharia institutions such as Sharia court and institutions with authority in religious affairs play an important role in upholding Islamic law. As a Muslim, it is important to respect and cooperate with this institution to resolve disputes or legal questions related to religion.